And for this second panel, which we'll get started momentarily, just waiting for everybody to finish taking their seats, we're incredibly lucky to have Dean Sophia Lee of the University of Pennsylvania Law School to moderate. So with that, I'll pass it over to Sophia.
Thank you, Noah. And now you get to switch hats to become one of our panelists from being our organizer. It's really wonderful to see everyone today. So I think we're going to be like, we're the late afternoon jazz panel. So we're just gonna we're a little free form in how this is all going to unfold, but I know it's going to be fantastic. So I thought I'd start just by doing very short introductions of our panelists. They're all fantastic. And then we'll go in the order that everyone's seated here, and then have some time for questions after. So to my immediate left is Lisa McGurr. She's the Charles Warren Professor of American History and the director of the Charles Warren Center at Harvard University. She's a social and political historian of the 20th century U.S. She helped chart the new history of conservatism with a focus on grassroots conservative politics in her award-winning first book, Suburban Warriors: The Origins of the New American Right. And her most recent book, The War on Alcohol, Prohibition, and the Rise of the American State, makes important contributions to the historical roots of the New Deal state and the later 20th century rise of mass incarceration. Now, Beverly Gage, one more to my left, actually taught me this new history of conservatism at the very end of my PhD coursework and the very beginning of her teaching career. So I'm forever very indebted to her.
It was my first graduate class. It was very intimidating to have Sophia there.
I would have never known. Bev is the John Lewis Gaddis Professor of History at Yale University. Her first book was The Day Wall Street Exploded, A Story of America in Its First Age of Terror, which examined the history of terrorism in the late 19th and early 20th centuries through the lens of labor's confrontation with the state. And her most recent book, G-Man, J. Edgar Hoover and the Making of the American Century, won the Pulitzer Prize, among others, and uses biography to shed light on the grand sweep of 20th century U.S. political history. All the way at the end to my left is Noah Rosenblum. Everyone here must know Noah very well and already be very grateful to him, since he's been the organizing engine behind this rich gathering, brought us all here together, and been working really hard to keep everybody well-fed, very well stimulated intellectually, and having a good time. Let's see. Oh, somebody. There we go. I knew I had more on Noah. Noah's is like, wait, what happened to the rest of Noah?
That's fine. I'm all ready. We can end the conference now. It's the nicest thing anyone said about me.
Noah's an assistant professor of law here at NYU with an affiliated appointment in history. He's a legal historian of the American presidency and state, whose work sheds light on important questions at the intersection of administrative and constitutional law. In other words, for any of you out there who know my own work, this is really a dream panel for me of authors who've influenced my own thinking tremendously. And I think we're all very lucky to hear their take on parts 6 and 8 of Robert's sweeping and incisive history of the Taft Court. And these are the parts that touch on prohibition, labor, race, and state building. So I think we're going to have a rich conversation that can go in separate directions, and then also will intersect in interesting and important ways. So with that, I'll hand it over to Lisa.
Great. Thank you so much. Thanks to Noah and the other organizers for inviting me. It is an honor to be here to talk about Robert Post's book and its intersection with prohibition. I do want to say a word. Others have said, I'm not going to spend my limited time sort of lauding the book, which it well deserves, but I am going to spend a second lauding the book, which it well deserves, because a 35 book in the making that is a lifetime achievement of this scope and importance does deserve, I think, just a couple of words of praise, aside from the depth of what praise in sort of the analytic work. It's just an incredibly beautifully researched, richly analytical, but also narrated with stories that make it, despite 1,000 pages, an amazing read. So if you haven't had a chance to do so, you should read it. It is, I was assigned to do part 6 and couldn't help but read the other parts of the book because it's actually really exciting and enticing. And despite my own positioning, I already mentioned this to Robert, about my coming into Taft as an ideological opponent and where I sit, he came across as very sympathetic, and you can't help but be empathetic because of the way that Robert really does grapple with his persona and personality and character aside from his jurisprudence. I am not a legal historian, as is a caveat, and I'm sure Bev may expand and Noah as well, not Noah so much, but Bev may expand on that. We are both outsiders, I think, sit a little bit outside of legal history. I consider myself a social historian of politics. But obviously, Robert's work very much was both influential for me, and I hope a little bit vice versa. We both have had, I think, somewhat sort of intersecting things to say about the significance of prohibition. So I'm going to talk a little bit about that. So in some ways, for those of you that already read the book, or at least in my take on the book, I think it reinforces very much a sense of, aside from the sort of continuities of state building that people have pointed to earlier, in my mind, it actually really emphasizes the incredible pro-business ethos of this era in the post-World War I period. This extent of the kind of rollback and an interregnum, one could say, between the progressive era and the New Deal. These 3 Republican presidents really did roll back many pieces of progressive legislation, and the Taft Court was really essential to that right-wing turn. You cannot read this without being hit over the head again and again at the extent of the jurisprudence, whether it's minimum wage laws, whether it's labor injunctions, whether it's forced mediation, the extent to which there was a kind of turn against the effort to use positive law to remedy social and economic inequities and to build a more sort of equitable system. In my mind, I couldn't help but read this with without the contemporary moment in mind, given current concerns over the court's politicization and right-wing tilt today and its lack of legitimacy. The history is really relevant and timely, and the extent to which in 1924, obviously others have talked a little bit about this, the lack of legitimacy of the court among many, and of course Lafayette's push for a constitutional amendment to allow for the nullification of judicial review speaks to the extent of which there was a strong, powerful current, at least, of challenge to the legitimacy of the court in a sense of its absolute politicization. Maybe not partisan in the direct sense, but certainly pro-business, and certainly in favor of special interests. And as Robert Lafayette put it, basically, one should be able to legislate without having the court constantly be overturning efforts to pass sort of regulatory forms of economic and social regulation. So I think it's just a reminder that the porous boundaries that we might think about today, the Supreme Court justices and the extent to which they are intersect with private economic interests is far from new. What is really notable about this sort of turn, let's say, again, the return to normalcy, as he puts it, or sort of this pro-business turn, or a kind of effort to undo the expansion of federal power that had come about during World War I. What does stand in full tension with that, of course, is the court's support of prohibition. And that's obviously what we're here to talk about mostly on this, or at least I'm to talk about on this panel. Prohibition was, of course, a radically ambitious reform. The effort to completely ban alcohol from shore to shore was, as Robert Post puts it, an extremely disorientating legal innovation. And he tries to puzzle through the stark tensions between the court's dominant legal conservatism in economic arenas and its uncompromising backing of prohibition. Its, as he puts it, four-square stand for enforcement was in some ways surprising, given Taft's own strong opposition to prohibition prior to its ratification. In 1914, Taft had labeled the prohibition the proposed Prohibition Amendment a dangerous proposition. He continued to oppose it up until its ratification. He was extremely prescient in arguing that it would require a tremendous expansion of federal policing officials in areas of the country that were not going to obey, which is precisely what happened. But once passed, as Bob Post illuminates, he stood as an unfailing tower of strength in favor of Prohibition's cause. And I think that is a really important sort of way in which there was a kind of visibility and growth of state power in an era that one often thinks about kind of retrenchment of certain forms, particularly regulatory power, and a kind of line of continuity between the Progressive era and the New Deal in terms of state building, but a particular form of state building, and I'll come to that. So in a particularly illuminating discussion, he convincingly argues that the massive flouting of the law, this incredible sort of sense of, the sort of way in which many, many Americans, despite these hugely ambitious efforts to enforce it, nonetheless, there was a huge appetite for drink and there were many, many violations, that it required a rethinking for Taft of conservative legal doctrine. In other words, Taft's own concern with law and order and respect for law in face of that flouting. So you see an intersection actually with the social and jurisprudence, because I think there is a deep concern about the respect for law, led essentially Taft to embrace positive law and muscled federal authority, along with somebody like Holmes, to back strict enforcement. Faced with Prohibition's unintended consequences, jurists actually on both sides, he tells us, of the political spectrum, rethought their earlier ideas. Progressives like Brandeis, for example, became increasingly skeptical of the use of positive law to reshape custom and oppose the expansion of government powers to enforce it. So there is a kind of a way in which, a really illuminating discussion, I think a rich discussion, is how there was innovative thinking among both progressives and conservatives, and you see a rise of a kind of creative thinking that basically disappears in the wake of Prohibition. So Brandeis, for example, in 28, coming out in favor of a right to privacy, something that we'd only see again with Griswold v. Connecticut in the 1960s, an idea of personal freedom, right? That kind of thinking in Prohibition. And on the other side, of course, the Olmstead law, which is very much about, expanding government surveillance and using positive law effectively and bolstered state power for conservative purposes, something that again comes to the fore in the Rehnquist court and beyond. Aside from this kind of innovative thinking, what's, I think, Post tells us is that Prohibition jurisprudence in some ways helped to open the door to a wider legitimacy of state building in the 1930s. And this is something that I also sort of built out in my own work. There's kind of the fear of conservatives like Taft, who had opposed Prohibition, not only it proved prescient, right? There were many in the 1920s that were constantly claiming, especially those in the Association Against the Prohibition Amendment, that this was going to lead to other forms of regulation. Right? That was part of the conservative opposition to Prohibition. And I think that really was the case by the 1930s, and I'll just say a little bit more about that before closing. Robert emphasizes the irony, in some ways, of Taft's contribution to the growth of central state authority through Prohibition. But in some ways, his abandonment of localism to back Prohibition enforcement, I don't think is terribly much of a surprise, in the sense that conservative jurists were more likely, or often conservatives backed localism in principle while abandoning it when it collided with the protection of property rights, and in this case, abandoned it for a different purpose in favor of law and order. And the government's primary role in enforcing Prohibition was to eradicate the traffic through criminal law, not through as much through the expansion of, obviously, the regulatory state. And conservative jurists have often been more supportive of building the law and order state. And Prohibition was an important moment of state building, but building the state in the realm of crime control, of policing, and of surveillance. And I think you see with the rise of mass incarceration after the 1980s and beyond, the way in which there is more conservative jurists are more amenable to that form of state building. I think that Post is very convincing in pointing the ways that the Taft Court's rulings upended customary understandings of federal and state responsibilities, and that effectively being one way of cracking open a door to other forms of regulation in its wake. The visibility of government authority throughout the Prohibition era, the new institutional spaces of power because of a crisis of law enforcement, whether it be from, sort of the need for prison reform to court reform, all of which came about, right? The sort of managerial revolution is partly because the courts are so clogged because of Prohibition, right? These are all consequences that last. Uniform crime reports, the Wickersham Commission, the elevation of the Bureau of Prisons to the Federal Bureau of Prisons, the growth, as I think Bev will tell us more about, of the FBI, its professionalization because of the corruption of the Prohibition Bureau. All of this is linked to long-lasting legacy. The Federal Bureau of Narcotics coming directly out of the war on alcohol or the Prohibition era. So, as I said, the conservative leaders of the Association Against the Prohibition Amendment had viewed the law as the opening wedge to the growth of government authority in other spheres, and it turns out they were right. Even the most ardent opponents of Prohibition, working class, urban ethnics, those who became part of the New Deal coalition, partly because they were so upset about Prohibition, right? Basically hated the law, but saw we've got federal authority, and actually made this argument. We can now use that authority and push it in a very different direction. So I think it really is really meaningful also for understanding what came about in 32 and how that form of state building 32 was different than what had come before, because it's a different class within that coalition and a different set of needs. So kind of a cultural mobilization around Prohibition and the hatred of it built a New Deal coalition within the Democratic Party in 1928 and 1932 that then reshapes the party and helps to build the New Deal. So essentially, I think Robert's book really does help us understand, and it was really influential for me when I started to begin the work on the book that's now been out for a while. This shows you how long you were working on this book. There was an article on basically Prohibition, the administrative state, which was the first time I had seen anyone take Prohibition enforcement seriously. And really make a case for how important it was to judicial thinking and rethinking. And so thank you for that, and thank you for this magisterial and fantastic book.
I have to say, I just want to say, when I was taking your class, Bev, I think when I was a student, Robert was working on this book even then. So it is a life's work.
Well, as someone who recently published a book that I worked on for more than a decade, I have to admit, I occasionally point out, I was like, this is nothing, actually. I know to you lay people out there, this sounds like a really long time, but actually, So thank you, Robert, for that, for setting the standard in so many ways. Well, I thought I would just pick up a little bit from where Lisa left off, both in appreciation for these volumes and in thinking a little bit about the politics of policing in the 1920s, because they were changing really dramatically at the federal level especially. And I think you see that reflected in sort of all kinds of sections of the Taft volumes. And I think you see a real fluidity in that at the courts as they're being faced with all of these new situations, all of these new technologies, all of these new laws that are produced both by the war and then by Prohibition and other things going on, that it's a moment of fluidity and uncertainty. I think, from the perspective of someone who does, like Lisa, social and political history, I think there's a way in which coming at this history sort of through the lens of the Supreme Court and through the lens of Taft and all of these very well-organized and very erudite conversations that we're having here, it makes it seem all a little more orderly than it actually was. And I think many of these challenges and many of these historical trends that helped to produce not only the politics that Taft was so immersed in, but that produced than the Taft Court are important. So I'm going to talk a little bit about all the messiness and some of the things that are happening outside of the court, but this is inspired by the beginning of Chapter 32 in particular, in which you note the ways in which the Taft Court throughout the 20s is preoccupied with questions not just of prohibition, but of quote unquote law and order. So I am coming at this through a lot of the work that I did writing a biography of J. Edgar Hoover. This is, I think, an interesting point of intersection in a couple of ways. First, we've gone to 1924 a lot, and I admit I wasn't here yesterday, so I don't know everything that was said, but one of the most important things that happened in 1924 is that J. Edgar Hoover, as a 29-year-old, was appointed to this little tiny part of the Justice Department known as the Bureau of Investigation. He was appointed, we should note, by someone who goes on to be very important in the Taft Court. So Harlan Stone was then Attorney General. He was the one who looked to this young man named J. Edgar Hoover and said, "You seem like an upstanding young fellow, obviously a reformer, obviously someone who shares many of my ideals and values." So from our perspective, that can seem kind of funny. But I think there's actually real points of resonance between these two figures, and it's worth noting that Stone and Hoover had a very long-standing relationship from that moment that Stone appointed Hoover. As Hoover rose and as Stone rose, right, in the court itself, they maintained a very active correspondence. They considered themselves to be quite similar, to see the world in similar ways, and we've been talking a little bit about, certain inappropriate relationships that Supreme Court figures have had with political figures, appointees, et cetera. There's some real back and forth about many things that are coming before the court. So I think Hoover is an interesting point of intersection with all of this. There are two other features to mention about Hoover that I think are important in some of the discussions that we've had, and then I want to return to the broader question of law and order. First is that one of the things that got me interested in him was that he is almost a pure product, not of politics, but of the state, right? He's a figure who is born in Washington, D.C. He never joins a political party. He never votes. He never works for any institution except for the federal government. He is sort of born into this world. It's his first job. And then he dies in Washington with the same job that he got at 29, and he is 77 at that point. So he is an interesting figure through which to look at the state, but I think he also helps us to see sort of how complicated the politics of the 1920s actually are in determining how to characterize people around a lot of the questions that have come up over the course of this conference already, right? There are certain elements of Hoover as a young man and as an older man that are reactionary or conservative. There are others that we might describe as progressive or state building in one manner or another. And I think Taft is actually a very similar figure in that sense, that there's a whole jumble of all of these things going on all at once. And so from certain lenses, he is the great figure of reaction, right? But of course, he, in many instances, is describing himself as a progressive. Certainly when he was an active politician, he's describing himself as a progressive. And I think that we shouldn't dismiss either one of these out of hand. I think this is kind of the chaos of 20s politics, as seen through a figure like Taft, as well as a figure like Hoover. The other thing that I will say about Hoover is that he's a pretty good argument for why thinking about the 1920s as a period of transition, but as a period with really long legs. As I said, he got that job in 1924. He left that job by death in 1972. But many of the ideas that Hoover and many other officials in the government went on to implement over that period, you can see not only just percolating during this earlier period, but actually fully formed in lots of ways, and that the story of the 20th century is in some sense a story of implementation. So that is a little bit of where I'm coming from, just in terms of my own thinking about this period. And now I just wanted to say a few words about the broader politics of law and order as they seem to be emerging during these critical years, first of World War I, and then into the 1920s, and the ways that they are shaping these forms of policing, particularly at the federal level. Federal police in particular, police in general, from the teens into the 20s, are in a period of incredible flux, some of it innovation, and a lot of it just chaos, because all of a sudden, they are faced with a whole set of new social challenges, some of which are being given to them sort of from the top down, new legislation that's coming about, others of which are kind of burbling up from below, expectations that people have about what the federal government's going to do, and particularly about policing, that come together in this pretty chaotic way to begin reshaping how policing in the country is done. Lisa's already talked about one of them, right? Prohibition, so critical, not just to the general history of policing, but to questions of federal policing and federal jurisdiction in particular. But there are many others, right? The wartime state is one of the things that happens in the Justice Department is that suddenly, almost in a moment in 1917, they are just dumped with all of these things that they actually have no idea how to do, right? They are given draft enforcement. They are given the enforcement of the Sedition and Espionage Acts. They're given German registration and internment enforcement, right? They have neither the apparatus nor the know-how actually to execute on any of these things. And so while I think we can consider World War I and Prohibition as periods of state building, as we have been discussing, I think for most of the people who went through that and were actually trying to build the state during those years, this is incredibly kind of contingent, crisis-ridden process. It's producing all sorts of not only court decisions, but actual kind of tangible experiences on the ground. And that I think for a lot of the people who went through the experience of World War I, you are, in some broad sense, getting a larger state coming out of it. But a lot of the way that they are narrating what happened in 1917 through the early 20s is as a failure of the state, right? That a lot of what World War I does is showcase the ways in which there actually isn't the kind of administrative capacity. I mean, lucky, we won the war, great. But actually, a lot of what people learn is that we don't have the administrative capacity to do many of these very ambitious things that people are starting to think about and expect in a war context and then after. So it's a period in which people are learning very, very rapidly to take on all of these new duties and are beginning to expect that in different ways from the federal government. And then you have a whole series of new technologies which have already come up. Some of them at least. You have the advent of cars, right? So cars, not just a question about search and seizure law and how we're going to think about cars. Cars are a problem because they can cross state lines really, really fast, right? They can outrun the police. The local police aren't supposed to cross state lines. So what do? Who's going to do that? How are you going to coordinate it? You've got those sorts of problems. You have all this new communications technology, right? Wiretapping, most prominently in the Taft Court, but a whole series of different communications technologies that are transforming policing and that therefore, are making their way up through the court system. And then another one, which I think doesn't show up as much in the book, is just weaponry, right? This is an era of, partly because of the war, partly for other reasons, of technological innovation, particularly the machine gun and the Tommy gun, which come in as weapons that people are using through organized and less organized crime. So there are all of these things underway, and I think that you can see them all sort of bubbling up over time in the 20s to the Taft Court. Questions about civil liberties, questions about federal jurisdiction, questions about search and seizure laws, questions about wiretapping and surveillance, questions about political intelligence, questions about free speech, right? So those are problems for the court, but they are being produced by these kind of practical challenges for police on the ground. This overall does result in a kind of expansion of federal enforcement. But of course, the court seems to have a kind of mixed relationship with all of that. And I think it also produces a set of responses within policing that are actually quite deliberately designed to stay out of the mess that seems to be happening in the kind of formal realms of the law, of policing, certainly of prohibition. And you can see kind of bureaucratic innovators like Hoover looking for realms where they're not going to have to engage that kind of chaos, and in particular, where they're not going to meet the sorts of legal challenges and questions that are burbling up in so many other places. Hoover spends the 20s not engaging in very high-profile action, and he desperately wants to avoid prohibition, but instead engaging in a set of kind of institution and administrative innovations that are designed, first of all, to reform his bureau, which has not been in very good repute, and also to kind of contribute to this state-building process. So in a very short period of time, suddenly the federal government is doing things like collecting fingerprints, right? Local police are sending all of their fingerprints up to the federal level as a sort of clearinghouse. They're beginning to collect crime statistics in a significant way for the first time. They're beginning to do training of local police on the ground through kind of federal ideas, and they're trying to become sort of scientific innovators, right? And part of this is designed to kind of carve out a realm of administrative discretion that's going to be separate from all of this chaos that's going on in so much of the rest of the world. So I think Hoover is an interesting figure, like Taft, in watching what is both a state building and, I think in his case, a state limiting process. He, though he's very friendly with Harlan Stone, actually, is trying to kind of stay out of a lot of the decisions and a lot of the conflicts that you described so well, Robert. I do want to cite one wild story that is in this book, which is so full of, not only footnotes, but great stories. And this is the prohibition judge who is trying desperately to kind of keep up with everything that's happening. J.F. McGee has this great name, the Bootlegger's Terror, right? Because he is going to be the one federal authority that can keep up with all of these cases coming in. So the story that Robert tells is that on one occasion, he sentenced 112 liquor law violators in 193 minutes, right? So the pace is fast here, but and I think this is representative of a lot of people trying to handle this stuff. He gets so overwhelmed that it literally does him in. He actually, and this is the tragic part of this amazing story, he kills himself, and he actually, in his what I take to be his suicide note says, I've tried so hard to keep up with all of these prohibition cases, and I can't, and I just have to get out, and this is the end, and that's it for me, right? So that's an extreme case, but I think is representative of this sense of real chaos and despair. All of which is to say, state building is a messy process. It's a messy process for those who are engaged in it. It's the messy process for those who are subject to it. And it's a messy process for those at the court, like Taft, who are trying to, create some sort of coherent system in this world of very, very fast challenges. The last thing that I wanted to say about the politics of law and order is that I think in a lot of the conversation here, and I think in a lot of the conversation that happens in our public discourse, right, the phrase law and order, the world of policing is described as being reactionary, conservative, repressive, and there are certainly many, many elements of it that play out this way in the teens and the 20s and into the 1930s. But one of the things that's been really interesting to me, and again, I think you see it reflected in some of the ambivalence that emerges in the Taft volumes. There actually is also a really interesting progressive tradition of quote unquote law and order, and that even law and order as a phrase is a much more capacious and much more interesting phrase than we usually give it credit for, right? So often we're thinking back to the politics of the 1960s, right? A figure like Richard Nixon, who sort of takes law and order, makes it this conservative or reactionary form, or thinking, in the present about someone like Trump, right, who has claimed the politics of law and order. But during this period, I think there's a really interesting kind of liberal progressive law and order politics that we've kind of forgotten and written out of our history. You can see it in the ways that civil rights and anti-lynching activists mobilize or try to mobilize a language of law and order to say, these vigilante mobs, the Ku Klux Klan, right, all of this, they're trying to summon the state to protect them from violence, and they're using a language of law and order. Left-wing radicals and progressives and socialists are adopting the language of law and order to protect themselves against vigilante mobs, against other violent attacks. And I think most interestingly to me, and this is something that you really do see emerge in the 1930s, I think out of the politics of the progressive era in the 20s, a figure like Franklin Roosevelt, when the New Deal comes along, he's not only building a social welfare state, but he declares a war on crime, which has certain reactionary aspects to it, but also is part of a kind of broadly liberal claim during the 1930s that if you want to be able to live a good life, right, you want to be able to fully participate as a citizen, you want to achieve security, kind of that buzzword of the New Deal, then being safe in your person, right, safe from crime, having responsible and responsive police, right, that too is part of this liberal vision of the 1930s. I think it's something, as I said, that gets dropped out over time, often for good reasons, but something that we might want to recapture in thinking historically about this period, the teens, the 20s, and into the 30s, and the influence of Taft. Thank you.
So I'm really just delighted to be on stage with three scholars whose work I admire so much, and some of whom have been teaching me since before I can actually remember, as Lisa knows. I have three thoughts to share about Robert's fantastic book, and they follow almost exactly on some of what Lisa and Bev have just laid out for us. One is about Supreme Court-based legal history, so I'll just play the legal history card and speak a little bit about it as a legal historian as opposed to a real historian. A second thought that I have is about state capacity and the history of the state. And since we lost our labor history panel, I'm going to try to connect it a little bit to labor, which is such a crucial theme in the book and in this period. And then I'm just going to end with a few thoughts on the 1920s and thinking about the role of courts looking forward. So Supreme Court legal history first, and here I'm just going to do what Lisa sort of adumbrated and praise the book and even try to flog some copies. I have some discount codes if you want to buy it at 25% off, which means it will still only cost you a small fortune. Okay, Supreme Court legal history occupies a complicated place in the profession, and honestly, even in my own personal psychodrama as a budding legal historian. When you're first training in legal history, you don't actually know what legal history is, right? You can't. You haven't gone to law school yet. So you're trying to figure it out. And the temptation is to look at people who write about the history of the Supreme Court and go, oh my God, that's legal history, isn't it? Because everybody knows about the Supreme Court. It's big. It produces cases. There are a lot of them. They go back a long time. You can line them up and tell stories about it. And you can think, wait, maybe I can do that. And if I do that, I too can be a legal historian. But then you go to graduate school and you earn your PhD. And along the way, I think you come to look down at that kind of history, the lining up of Supreme Court cases. It's often superficial. A lot of people who do it trace false connections. They gather cases that look alike. They look at what the judges say about how the cases relate to each other, and they take that to be the history, and then they just regurgitate it. It doesn't get the whole story, you learn, right? The law is so much bigger than what actually happens in courts. And if you actually do try to become a real historian, then you get to do things like go to archives, and you realize that court-based approaches seem way too easy. They make it feel like you're cheating, right? All the sources are right there in front of you. You can just go to your computer, plug them into Westlaw, and pull up the cases. Where is the hard work, the grit, the sweat, the strange cities that you don't want to necessarily spend too much time in, the thumbing through difficult to read handwriting, all the stuff that makes you a real historian. And now you're a fancy legal historian and you go to parties and you say, I'm a legal historian. And they go, oh, does that mean you write about the history of Supreme Court cases? And you look down your nose at them and you say, no, you rube. That's just what you imagine a legal historian to be. And then you spill your drink on them and you go back to reading the minutes of the President's Committee on Administrative Management in an unair-conditioned room in the Hudson Valley or whatever else you might be doing with your summer. But Robert's book reminds us why Supreme Court history really does matter, why the Supreme Court can be important, and why I just need to get over my psychodrama. While it is true that obviously the law is about more than just what happens in courts, the law is also what happens in courts. And in the United States, since at least Alexis de Tocqueville's famous quip about it, major political controversies and most other controversies eventually do somehow or another find their way into court, or at least leave some sort of a trace there. In other words, you can use the courts as a lens through which to refract broader social developments. And there's maybe even an argument that at some moments in time, the United States Supreme Court can be a privileged lens, right? We talked a little bit about the judge's bill, how that changes the court. Certainly when it comes to some of the most important issues, some of the issues that divide the polity most fundamentally, that cannot be resolved simply or easily, the ones that can't be settled in other places, eventually they will percolate through the court system and they will probably leave some sort of a mark in the United States reports at the Supreme Court. Now, if you want to use the Supreme Court this way, it's not easy, right? It doesn't mean just reading the case for its holding. It doesn't mean looking at the case for what it says about prior law or its facts in this kind of straight reading for its manifest content, right? You need to read it for its latent content. You need to read the case as a trace in the reports of broader social conflicts and deeper transformations. We have to use what we can see, that is to say the words of the law, the case report, to reconstruct what we cannot see, right? The disagreements, the institutional transformations, the social forces that generate the conflicts that eventually wind up in court. And Robert's book does this in just the most exemplary way. I think the volumes show us that you can, in fact, make this unseen world visible if you use the cases to redirect your research in those other directions. And so Robert doesn't just reconstruct the cases for us, he reconstructs the broader world those cases are a part of by delving into a simply heroic volume of primary sources. You really do get the feeling that he has read every word that was written by the people on the Taft court for the 9 years that they were on the court, and perhaps every word written by Taft and those justices' friends over the course of their entire lives, right? All to bring it to bear on the particular cases that happen to be decided during the time that this volume covers. So this makes the book triply valuable, which is why you should buy it, right? First, it does do that like old-fashioned cocktail party Supreme Court history, and it does it just as well as it could possibly be done. So you may poo-poo it in grad school, but then perhaps you find yourself actually having to teach about cases you know nothing about, and it's wonderful that somebody else can explain them to you, and Robert's book really does that. So if you just want to know about the meaning of Truax v. Corrigan, you can read the chapter. He will tell you what it means. Okay, but obviously it goes well beyond that. This is the second way in which it's really valuable. By analyzing the cases as social symptoms and using them to reconstruct the various pathologies that the body politic is grappling with, the book becomes a kind of diagnostic guide to American history. And finally, and this is an act that I can only describe as pure scholarly generosity, Robert doesn't just give us the diagnostic, he lets us peer behind into how he made that diagnosis by giving us actual access to his sources. non-academics will relish how well written the book is, right? You can just pick it up and read it, just as Lisa and Bev were talking about. It really does make good reading. You can bring the book home to your friends, at least if they're super nerds. But scholars will appreciate that Robert shows his work, all of it, right, in the text and especially in the footnotes. So this is a conference full of historians. We all know how dangerous it is to use a word like authoritative, but I have never been more tempted in my life to describe a book that way. If another book is ever written on the Taft Court that displaces it, that book will build on this book, and it will almost certainly draw from the sources and arguments that Robert gives you access to through his book. Okay, so what do we actually learn about American history if we use the book in this diagnostic way, when we use the court to pry it open? Well, that takes me to a second set of reflections about state capacity, which sort of a gesture towards labor, which are really just going to echo what Bev just said and what Dan said on the previous panel. So one major theme that comes across is just a total confusion about how society should be organized and what role the state should play in maintaining social order. Now, in some ways, this is a very old way of talking about the period. This book was mentioned yesterday, I think, by Tom Segru. Robert Wiebe has a classic book on the progressive era called The Search for Order. But Wiebe's book ends in 1920, and Taft takes the bench only the next year as a Supreme Court justice. Maybe one way to talk about it would be to say that it's clear by 1920, by the end of Wiebe's book, that the old ways of doing things aren't going to work anymore. But it's not obvious what it would mean to institutionalize a new way of doing things. This abstract way of talking about the period, I think, can become a little bit more concrete when we turn back to the suggestion Andrea gave to us a couple panels ago about grappling seriously with the return to normalcy idea and the recognition that there is no such thing as a return to normalcy, right? World War I does lead to massive changes in state organization. Along the way, the state learns a lot of things about itself and its populations, those it's trying to govern and discipline. With the end of the war, this leads to at least two governance puzzles. One is just what lessons should we take from the war? If you are a young man who's joined the government and is a bureaucrat and has that kind of ordered sensibility, what does order mean now when we have done this new thing? And second, how are we going to manage the pathologies that we now know about because of the war and that the war itself is going to help create? So what do I mean by that? Well, the war made it clear that government just could do so much more. It could take on these tremendous social and economic challenges. To be blunt, it sort of exposes the bankruptcy of a small-bore individualist way of thinking about things. In its place, it suggests the power of those who count and aggregate, the accountant, the manager, the social science expert. They know something that other people just don't. It also confirmed that this was an era of mass organization, of mass labor, of aggregate social forces. Society was a thing that could be known or at least studied, maybe managed, perhaps controlled. But society was changing too. As Kim observed, I think it was earlier today, although it might have been yesterday because I've entered that conference headspace where time is a flat circle. There was no putting the genie of possibility back into the bottle after World War I. The possibility of another life was something that couldn't be repressed, and that was true for many people, but particularly for Black veterans. Of course, some try to put the genie back in the bottle, and so we have massive waves of racial violence and the forces of capital asserting themselves aggressively after the war, but that just becomes another social pathology for the post-war state to have to learn how to manage. And so this is where I think Robert's diagnostic becomes invaluable. As he shows us, Taft himself cannot unlearn the lessons of the war. It is a world of bigness. The state is just going to manage with bigness. And in some ways, the Taft Court just knows that. It's not interested in making this new world of bigness, but it can't pretend that it isn't true. They're going to have to address the challenges that have now surfaced using the tools they have, but for the most part, without trying to transform that world into something else. They're not revolutionaries. There are lots of examples of this, but I said I was going to gesture towards labor, so let me gesture towards the labor jurisprudence. Right? On the one hand, it's a world of individualism, a world of free labor. We don't want to enter the new world.
And so combinations to withhold your labor are suspicious, maybe even criminal. You're preventing someone from selling their work. The scab, as Robert Post notes, in this vision is actually a kind of hero, the strong individual resisting the social pressure to sell their labor as a free man in spite of the violent combination trying to get them to stop. And yet, the age of the mass makes it clear that you can't actually stop the organizing either, and it's not obvious you'd want to. Right? In part, Taft knows this from his experience during World War I, mediating conflicts between labor and management as part of the associational state to enable war production. In part, it comes from his knowledge of this new society. For labor and management to negotiate in the age of bigness, you're just going to have to empower labor a little bit because no individual laborer is going to be able to strike that contract. And so we're going to have to get some organizing. And so we see a court that is temporizing, adapting, a court that won't overrule earlier cases that disempower unions, like Hitchman, but it's not going to extend them either, and maybe it is going to try to cabin them in something like the Tri-Cities case, but then again, you're not going to totally empower labor either, and if the judges are going to intervene to protect them against lawlessness, they'll do that too in Truax. I was talking with Bill Novak about this earlier. The image that I keep having is of a kind of reluctant modernization, like a swimmer being borne downstream by the current, trying but failing to swim against it. I think an earlier subtitle for the volumes was The Ambivalent Construction of Modernity. So this takes me to my two closing thoughts about the 1920s and today. So first, right, a major theme in this book is this ambivalence, this ambiguity. We see the return of judicial supremacy, to putting judges in charge as a way of trying to tame the madness. But what are those judges doing when they're in charge? Well, they're often consolidating change, whether it's with labor, as we've talked about, or with presidentialism, which Andrea Katz and I have written about in the incredible Myers case. This is a posture, let's say, somewhere between the Warren Court and the Roberts Court of today, right? The Warren Court, the bleeding edge of revolution, the Roberts Court, the bleeding edge of reaction, I guess. Here, not a bleeding edge, right? A genuine attempt at conservatism, almost in this kind of Burkean sense, with the good and the bad that comes with it. Not reactionary, but also not revolutionary. But, and this is the second point, and takes us back to the way in which doing the Supreme Court history can sort of pry open the broader world, right? What is, on the one hand, this position for a judge as conservative is very old-fashioned, but does the meaning of that conservatism, is it found in the cases alone? And the book shows us that the answer to that question is also obviously no, right? The meaning of these decisions, and even of the Taft Court, doesn't end with these rulings. So as the book beautifully shows, some of the rulings occasion reaction. They occasion organizing. And I think that there's something here to reckon with for today in thinking about the role of courts, right? So to go back to the gesturing towards labor, Taft refused to embrace the group system fully, reluctant modernity or whatever. But of course, the Hughes Court would, right? The Hughes Court would have to. And they would have to because of these social and political changes that would set in motion a different political order in which it was acting. That court and the world that put pressure on it was the product of massive social and political change that itself was brought about in part in reaction to the conservatism of the Taft Court trying hard not to be reactionary or revolutionary. Even conservative courts and men genuinely committed to conservatism, like Taft, can try to make their peace with modernity piecemeal and nevertheless provoke the reactions that might sweep them away.
Wonderful. Well, by the clock, we have about 18 minutes left to us. So I do want to start by opening it up to the floor rather than taking it myself. Yes, right over there.
Great. So I had a question for the panel more generally, because we rarely get an opportunity to have three historians of state capacity in various capacities. So, if you study the welfare state or other places, you can have a kind of story about the push and pull, the shrinking or expansion. But it seems like, and feel free to correct me, and I suspect as a historian you might be reluctant to go in this direction. When you study policing, there tends to be a tilt or a particular skew about state capacity. The question is never shrinkage versus does it shrink or expand. It's has a tendency towards expansion because of an interaction between, let's say, technological growth, like the growth of just group capacity to surveil, control, police, and the imperatives of the state, whoever is in office. And so, if you're studying policing and state capacity, do you think you come into it with, let's say, not ironclad, but some presumptions about bent or skew about state capacity, and what really sort of is the material? The real question is just how did it expand rather than did it expand? And feel free to reject the tendency question in the first place.
Well, I have a few thoughts about that. So one, I think one of the challenges of policing and the state is that really in policing, I mean, sort of as with education and many other areas, there isn't any one the state, right? So that policing in this country, the way that it's organized is so diffuse that you have all of these multiple stories. You know, we were talking primarily about federal policing here, but even at the federal level, right, one of the challenges throughout the 20th century, and I think well into this moment, is a challenge of kind of cooperation. So just measuring, right, measuring the size of one versus the size of the other, is there a skew? I mean, I think I would generally say that you are correct to think that there is an embiggening over time, but I think that that is one challenge that complicates that story. I think another one is that police officials often set out to reject certain duties. So one of the things that was interesting to me in thinking about a figure like J. Edgar Hoover, he is known as this kind of power broker, this empire builder, right? The one who wanted more, 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 more. It's actually not true. There are lots and lots of things that he did not want to do. Now, sometimes he just wanted someone else to do them because they were troubling or complicated, right? He actually wanted nothing to do with prohibition, and that was true of a lot of police officials, right? Here's this moment of massive opportunity, but actually a lot of them want nothing to do it because they don't think they're going to be good at it. They don't think that it can be done, and there are a variety of other reasons as well. So I don't think it's a straightforward story of growth. And then the last thing that I would say is that I think we're just beginning to get a literature that looks at police not just as administrative actors or carriers out of law or repressors, but as actually kind of complicated political actors in their own right. Professional police organizations, police unions as they ultimately come along, right? They actually have a very complicated set of politics around these sorts of questions. In general, it's true. They want more power, they want more influence, they think they're great. But they also have their own sense of limits and of places that the police can't, shouldn't, and don't want to go.
So a little bit of a follow-up on that. It's a great question, actually. And I think, I've thought about that, because part of, looking at prohibition is to understand, or what I was trying to do was understand, what are the long-lasting legacies that go beyond rescission? And clearly there are many which speak to the idea that once you build, it's very hard to unbuild because you created institutional spaces and the folks that are there, they're going to move from one place to another, but like somebody like Harry Anslinger finds a new place and becomes a czar for, drug wars. That said, I think it's really what's important, and speak to something that Bev was getting at, there's a process of learning, right? So, in this idea of chaos that Bev had brought up, there is a way in which, Margot Kennedy is the word that the state puzzles before it powers. And in some ways with prohibition, you see the state powering and overpowering. And what you get with rescission, in a way, is that there's a process of learning how to police, or appropriate ways of policing, professionalizing policing, reforming the state, in order to allow for this kind of policing that is going to not be so highly controversial, but is still very much empowered. So the federal government never loses its capacity for policing, as the FBI continues to grow. But it legitimizes and operates in different ways. So something like prohibition, obviously, the federal government learns, we're never going to do this again, we're never going to have a constitutional amendment. Drug prohibitions continue, but with an alliance between the federal government setting the schedules and the police at the state taking a lot of responsibility. So there's a way in which there are different levels and there's a learning process. So I think the idea of the notion of, the state puzzling for its powers and then, sort of overpowering and learning from it. So I don't think it continues to grow, but I think it sort of learns lessons and grows in different ways.
One of the things that always bothered me about prohibition is it never became an anti-canon for construction of constitutional law in the same way that, say, Plessy became an anti-canon for equal protection. Like, we know how not to do equal protection, don't do Plessy. We know how not to do substantive due process, don't do Lochner. But you'd think it would be natural to say, we know how not to do federalism, don't do prohibition. I mean, that was sort of the morals that lots of people drew from. And there's cases that nobody reads anymore. I mean, I love Robert's discussion of Everard's Breweries v. Jay. Who's ever heard of Everard's Breweries v. Jay? But we can cite Sutherland's dissent there in, say, a case like Gonzales versus Oregon. Because, like, that's a case where, the majority says, oh, well, the power to prohibit liquor for the purposes of drinking it includes the power to prohibit liquor for the purposes of, regulating medicine and prescriptions by doctors. And Sutherland goes crazy and says, where does the federal government get to regulate doctors? We have exactly the same issue with Gonzales v. Oregon, because the federal government, as John Ashcroft or Alberto Gonzales, have the power to regulate physician-assisted suicide. And Kennedy writes his federalism opinion. No, we can't construe the Controlled Substances Act that way. But there's no discussion of prohibition. There's no discussion of this failed noble experiment. There's no discussion of any of the rhetoric about how you can't impose on a nation a one-size-fits-all thing. Remember prohibition? And God help us, we're not going to cite Sutherland's weird dissent in this long-forgotten case. Why not? Why isn't prohibition and art cited whenever the court says when there's sensitive areas or traditional areas of state concern? Do you guys have any theory?
Want to try that, Noah?
Well, I'm tempted to say if only there was a body of literature thinking about the role of social movements in constructing the way cases become historical and precedential. Perhaps one might even think that social movements and judges play memory games to suppress some forms of precedent at the expense of others. That would be my pitch and suggestion. But until somebody directs me to that body of literature by Reva Siegel and Robert Post, I would really be at sea myself.
I'll add one quick thing, which is that I think on the administrative side, there is that history. I mean, a figure like Hoover, and there are others, Anslinger to some degree as well, though he's building upon it. Hoover stakes his whole career on, we are not doing that again. That was unpoliceable, right? It produced more crime, has all these vigilantes, lowered respect for law and order, et cetera, et cetera, et cetera. So I think there is a learning that's going on, but the interesting question is, why is it showing up in one place and maybe not the other?
And there's also, if I can the more serious, now that you bought me time for a more serious answer, I would say that maybe also we're thinking about the federalism revolution of the 80s the wrong way, because implicit in your question is something like the way to think about these federalism arguments is as related to doctrinal evolution. But if we think about the Rehnquist turn to federalism as itself the bleeding edge of a reaction in the way governance is going to happen, that doesn't have a lot to do with federalism, but has a lot to do with using jurisprudential tools at hand to shrink certain regulatory capacity in some places and expand it in others, that I think helps us make better sense of the flip-flopping and incoherence of those Rehnquist federalism cases, and can also explain why there's no attempt to reconcile it with earlier jurisprudential lessons on federalism, such as, for example, those related to prohibition.
Yeah, Bill.
This is really something for Lisa, but maybe others of you want to deal with it. I don't know how chaotic, I absolutely agree with the chaos in J. Edgar Hoover's life. I don't know how chaotic it is in the Supreme Court, for two reasons. One, a court is a court, and it can only hear cases that other people bring to it. It doesn't have the capacity to generate for itself a discussion of important issues. The other is that when it comes to prohibition, and this really goes to the whole question of how important prohibition cases are in thinking about the future, it's a constitutional amendment. And the court obviously has a job of enforcing the Constitution. And much as they might want to enforce privacy or federalism or some other value, they've got this constitutional text in front of them
Right.
saying that the federal government has this power. And think about it, if there's another area where we really would not like to see the enforcement of things against an explicit text. Think, and they're pretty close together in the 1920s. Think of the 16th Amendment. The federal government has the power to levy taxes on all incomes. If you start talking about other policies, other constitutional values, but not necessarily textual ones, contrary to the 19th Amendment, what do you do about the 16th Amendment? And do you really, want to get into that? You can't get into that. The federal government and your salary are dependent on the raising of that revenue. So I think there's a certain order that the nature of courts that they can't just decide, here's an important issue we have to decide, they have to have a case brought to them. And the fact that the 19th Amendment is a nice, clear constitutional amendment, very much limit and order how the court can think about things. And I can't overemphasize it, because there are, in cases where the amendment controls, there are dissenting opinions. You can think of arguments you can make why the text should not be followed, but those arguments are all problematic, especially when you think about them in the context of.
So I think it's a great point, and I think that's precisely what is so significant about prohibition, is that it's a radical innovation to have a constitutional amendment to do something to regulate not liquor traffic, but also essentially then private behavior, right? So that is very controversial, but at the same time, the justices need to uphold the law. This is a law which is, followed by the Volstead Act, the enforcement legislation. And I think that creates a quandary for somebody like Taft, who clearly, was not supportive of this, but it's now the law of the land, ensconced in the Constitution. Even opponents like Felix Frankfurter, who had, again, very much progressive, totally opposed to left. We need to give prohibition a chance. It's part of the Constitution. We have to work at enforcing it. So absolutely, I think that is, why it was so problematic and controversial. And Taft, late in, I think it was in 28 or so, around the time of the Olmstead Act, wrote to his son and said that there's more feeling engendered about prohibition. It's the most difficult question, in other words, he's writing to his son, controversial. There's more feeling about this than any other topic that comes before the court. And so it created a real quandary. And it was, and I think precisely this, what Robert points out so beautifully, is that therefore it created this sort of like puzzle of thinking and really having to come up with creative solutions that brought together somebody like Holmes and Taft, while Brandeis is then rethinking his idea of positive law. He's like, oh my God, but we can't use positive law to change custom. And so you get, in a way, a whole rethinking, ascendant liberalism on the one side, liberal thought, but a kind of positive law thinking on the other side. So it just is, I think, really interesting that it creates these, really, I think you put it well, a disorientation in the court. And that's really more the point. It's not that, they should or they shouldn't. It's just, this is the situation, right? It's a really fundamental, radical shift that came out of contingencies, especially the war. I don't think we would have gotten that kind of amendment that we got without the war. But resulting from that and the Volstead Act making it kind of very strict legislation, meant that the judges were, especially judges who were sort of very much, like somebody like Taft, who had a very strong idea of respect for law, in contrast to Brandeis, who weighed down then in favor of privacy, that to enforce the law. So, it's an absolutely important point.
We have one last question in a couple
Well,
minutes, so let's make
seems to
it.
me that, given past prior reluctance to prohibition, when you look at the writings in Olmsted versus the United States and Carroll versus the United States, which don't directly confront the amendment, there's Fourth Amendment cases, and he could have massaged them, but he chooses not to.
Yeah.
And you got to wait to Katz in 1968 to get rid of Olmsted. And Carroll, to some extent, its legacy still governs police stops to this day. So I think that's a really lousy job of personal autonomy, even in privacy property rights, in order to do a morality enforcement that he personally disagrees with.
So, but I think it's, again, I think it does speak to, this sort of the willingness of somebody like Taft who earlier was sort of this idea of, conservative in philosophy, right? Wanting to keep things, not have regulation move to the federal level, but was also very much a supporter of, well, I would put it as kind of law and order, right? And sort of respect for law was part of his very strong sort of set of beliefs. And therefore, I think it superseded the idea of kind of individual autonomy, privacy, or sort of localism, and, helped to build a kind of federal authority in that way over tradition and custom, over states' rights, right? In Carroll and other sort of legislation, right? Concurrent enforcement, et cetera. So yeah, I mean, it's a really interesting. Perhaps he could have done it. I don't know, but this is how it worked itself out. But I think it's also really interesting that Carroll still stands, right?
Yeah.
Because this is the way in which policing, these are innovations which matter, and they matter to today, despite precision.
That is a beautiful note to end on, right on the dot of 4:45. So thank you all very much.